Hello and welcome to Williams Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, a partner in the employee benefits section at Williams Mullen, and today I'm joined by Claire Pollock, a paralegal in our section.
Hi, Brydon. It's good to be here.
Thanks for being here, Claire. Today I thought we would talk about the status of the current wellness program regulations issued by the EEOC. The EEOC is charged with administering the Americans with Disabilities Act, and in 2016, the EEOC issued regulations that were effective January 1, 2017 on employer wellness programs. And you may be asking, well, why are we talking about regulations that were issued in 2016? And just a little foreshadowing, there's been some developments that have made this area a little murky.
Oh, now you're going to ruin all the suspense.
That's right. So the Americans with Disabilities Act has three basic requirements. It prohibits employers from discriminating against employees on the basis of a disability. It requires employers to provide reasonable accommodations to disabled individuals. And importantly, for wellness programs, it limits an employer's ability to ask disability-related questions. And so in order for an employer to ask disability-related questions or health-related questions under the Americans with Disabilities Act, the participation of an employee must be voluntary. The health information collected by the employer must be kept confidential, and then the health information received may not be used to limit the health coverage or availability of coverage that based on an employee's disability or health status. And so with respect to wellness programs, a lot of wellness programs ask for health information. A lot of wellness programs condition a reward based on an employee meeting certain biometric requirements. Cholesterol levels, blood pressure, BMI are based on, some rewards are based on employees meeting certain thresholds. Other programs give rewards simply for an employee to participate in a health risk assessment, regardless of the findings of the health risk assessment. And these disclosures of health information have been an issue under the Americans with Disabilities Act, because the Americans with Disabilities Act provides an employer cannot compel an employee to provide information. And so if you're providing a wellness program reward or incentive, the question is that incentive so great that you're really compelling employees to participate in a health risk assessment and give up their health information to the employer? Or are there surcharges? Do you charge more for health insurance premiums for employees who are smokers or don't meet certain criteria under the wellness program? And so for a long time, we had regulations under other federal laws that govern wellness programs, for example, HIPAA, that told us, the level of incentives and requirements to meet the HIPAA non-discrimination rules. But we didn't have any guidance under the Americans with Disabilities Act from the EEOC, or at least no formal guidance, no regulations. And so just from some EEOC enforcement actions, we knew that the EEOC frowned upon conditioning health plan participation on participation in a health risk assessment, or providing incentives that were high that made the program participation involuntary because employees felt compelled to give up their health information in order to get the incentive. But we didn't really have any clear guidance. So employers were complying with HIPAA, the HIPAA regulations, which set an incentive limit at 30% of the cost of employee-only coverage, or the level of coverage the employee was enrolled in under the plan. And we knew that complied with HIPAA, but really didn't have any idea of what it took to comply with the Americans with Disabilities Act. So it was really welcome in 2016 when we received regulations from the EEOC regarding wellness programs and what types of incentives, what level of incentives were permissible under the Americans with Disabilities Act. The final regulations applied to all wellness programs that offered by employers, regardless of whether the wellness program was linked to a group health plan. So even if an employer didn't offer a group health plan, if they had a wellness program with incentives, then these regulations applied. And it certainly applied to wellness programs that were linked to health insurance. And the regulations went into effect January 1, 2017, and we thought life was good because we could, especially for lawyers, we could tell clients this is what the regulations say. We weren't in this murky, foggy, fuzzy realm or area with respect to EEOC guidance. And so under the EEOC regulations, to have a wellness program, it had to be reasonably designed to promote health. There had to be a connection between the information you're requiring employees to provide and a health outcome. You couldn't ask for health information just to figure out how much you were going to charge the next year for premiums. There had to be a direct relationship between providing the information and a health benefit to employees. And the request for health information had to be voluntary, so employees could not be compelled or feel compelled to provide health information.
Yeah, so for instance, you couldn't require participation in the program, or you couldn't condition coverage in the health plan based on the participation in the wellness program, or the employer couldn't take any action against the employee for failing to participate in the wellness program.
That's right. And then there was the limit in the regulations that the EEOC finally gave us guidance that told us that an incentive of 30% of self-only coverage was the cap. That if you provided an incentive that was under 30%, under the regulations, you could be certain that you were complying with the Americans with Disabilities Act. But not everybody agreed with that. And in the summer of 2017, the AARP challenged the EEOC regulations and claimed that 30% was too high for the limit, that if you gave a reward of 30%, that it was coercive to employees. It made employees feel like they had to give or participate in a health risk assessment. And in August of 2017, the U.S. District Court agreed with the AARP and remanded to the EEOC that they rewrite the regulations or provide a reasonable basis for the 30% limit. And the EEOC said, fine, we'll do that, but there won't be any new regulations before August of 2018, which is a year later, and the regulations probably won't be finalized until October of 2019, and the new regulations won't be in effect until 2021. And the court wasn't really pleased with that result, and so the court vacated the incentive limit. So as of January 1, 2019, January 1 of this year, under this U.S. District Court's action, the EEOC incentive limit regulations were vacated, and the EEOC recently rescinded that portion of the regulations. So as of today, we're back in the kind of murky area that we were in before the regulations were issued in 2016, where we don't really know how high of how high of an incentive is too high for purposes of the Americans with Disabilities Act. All the other provisions of the regulations still apply. The program, it still has to be voluntary. The program has to be designed to promote health, but what we don't know is how much of an incentive you can provide to employees and comply with the Americans with Disabilities Act.
So what are you recommending that employers do?
Well, certainly as before we had these regulations comply with HIPAA, the 30% limit under HIPAA, and the disclosure requirements under HIPAA for alternative means of earning a reward, so comply with HIPAA. And we know the EEOC, at least very recently, thought 30% was an acceptable limit. So that gives you a little more comfort of applying the HIPAA limit of 30% and being in compliance. And so I think, it doesn't necessarily require a major change to what employers are doing, but we have a lot less certainty that what you're doing is in compliance with the Americans with Disabilities Act.
Is there any way by which the EEOC is policing wellness programs?
Yes, it brings enforcement actions from time to time, and there have been some lawsuits filed by the EEOC. So those, it is still possible. Regulations or no regulations that you could face an enforcement action from the EEOC. But I think you have a good argument that if your 30% limit is consistent with the vacated regulations, that it seems like a reasonable basis, but it's not as certain as it was before January 1, 2019. So that'll wrap up our discussion of the wellness program regulations. I'd like to thank Claire for joining me on the Benefits Companion. If you have any questions or suggestions for future episodes, please contact me. You can also visit the Employee Benefits Practice page at www.williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Also, be sure to subscribe to this podcast to be notified of when our next episode will post. Thanks for listening, and until next time.
Goodbye.